Hello, everybody. I am Mel Barrett, and welcome to Something's Off Retrial with Mel. Today, we are on day 9 of the Edrick Faust trial, and I'm hoping we're going to hear some closing arguments today. There's a lot of procedural stuff to get through. This is a 10-hour stream, which I probably won't get through today, but we will pick it up probably tomorrow, depending on what our schedule is. And I think we should just probably get into this as quickly as we can because there's so much to go through in this on this day 9. So we're going to do that after a really quick break. Hello, friends. There's only a few of you in here, but we're going to go forward anyway. Let's see. I think I have housekeeping stuff I should go over. We've done a couple of streams. We did 2 streams yesterday. One was for members only, one was open to the pub. And the first one we went over the Aidan Carney, Karen Reed, the new defamation suit against them made by the Haas defendants, or 4 of the Haas defendants. That would be Jen McCabe, Brian Albert, Brian Higgins, and Colin Albert, oddly enough. And there's a lot in there. And you should go and listen to the LawTube channels because they really handle the legal aspects of this defamation case. Rebecca and I were coming at it from the perspective of how anti-SLAPP in Massachusetts affects journalists or doesn't affect journalists, and whether Aidan Carney is a journalist. He calls himself a journalist. He, in my opinion, is a journalist. He's also an activist, and he's also a satirist. So there's a lot to dig through there. We had a good time on the stream yesterday morning, and then we had sort of a batshit crazy members only stream at 4:00 in the afternoon where we watched and reacted in real time to the new Carrie Roberts interview that came out with the channel Note My Objection. And there's really not much to say about it. It was chaos and it was messy and it was a shit show, but we had a good time. We had a lot of laughs and we had fun with our people. We are going to be doing, we mentioned this last night in the members only stream, but we're going to be doing another members only. There's 2 of them that should be coming up. Let me just grab my notes. Can I do this without freezing up? Well, let's see. So basically, we're going to do a regular stream coming up on Thursday. So that'll probably be in the morning sometime, maybe in the afternoon. Not sure yet. Waiting for Rebecca. And then on Monday, we'll do 2 streams again. We'll do one that is open to the public on Monday morning. And then at 4 p.m., we are going to be watching the interview that the McAlberts gave post trial 2, which Rebecca has not seen. I have seen it. It also includes Proctor. So we're going to be reacting to that in real time. I would expect it to go a little something like last night's went. And then once a month, we're going to be doing a members only offering where Rebecca and I do sort of AMA style stuff, but also we're going to do some pop culture review stuff. So I think the first one we're going to do is DTF St. Louis, which we've both watched and loved. So you're definitely going to want to become a member to watch those videos. And what else can I tell you? We're almost to 8,000 subscribers, which is nuts. It's crazy to me that we have 8,000 subscribers and there's only 6 of you here, 7 of you here. That's so sad to me. But I am appreciative that you're here, and I appreciate that Sean, Dancing Quinn, and Colleen became members today. That's very nice of you. And I hope that we'll get some more people in here because this is closing arguments for Faust. And the other thing is, I put a lot of time and energy into researching and obviously we're streaming sometimes for 3 to 5, 6 hours a day. It's exhausting, but I do it because I want people to come and listen to and watch this case so they understand what Edrick has been through. But if the retrial series that I'm doing if it's not gaining more traction, then I'm probably going to have to cut it just because it does take quite a bit of time out of my day to do one of these streams. Yeah, and I know there's a lot going on next witness. I know there's a lot going on on YouTube right now. But again, if there's only 30 people in here, it's tough for me to do it for 4 or 5 hours. So, but I'm gonna obviously take us through the Faust trial. I just don't know what to do next because I did the poll, and I announced this yesterday that the poll came out pretty even between the Facebook group and the YouTube group. You all want to see either Murdoch or Peterson, Scott Peterson. So I've decided I'll do both, but I'm going to start with Murdoch because there's more media available to me with Murdoch. So it'll be easier for me to start off with that trial that was heavily televised. And I didn't watch it in real time. I knew what was going on. I had seen documentaries. I've covered the case for a long time. Well, not covered. I've followed the case for a long time. And so, I'm excited to actually watch the trial and to see all the shit that went down that everybody was talking about that I wasn't watching because I was either I think I was doing Karen Reed at the time. I was also doing the In Between podcast, I think my first season. So I just have to make some decisions and figure out if this is going to be, worth the time that I'm putting into it. Because I am still working on a solid season. I would call it season 2.5 because I did a half season in between for the In Between podcast. And I've got a season 2 that's going to be coming out. And yeah, I have considered current trials. That's why I covered the Kelsey Fitzsimmons trial in real time. But there are certain trials that I really want to, put some focus on, like Faust trial. So when there's a current trial out there, I will definitely, we'll definitely be covering it. I don't know if we'll be covering it like every day like we did with Kelsey or, with Faust or with Karen Reed, because what we did with the readathon, especially with trial 2, is we would sit in court all day and we would listen to the trial. We would listen to the witnesses and the arguments and procedurals and all that stuff. And then at the end of the day, Rebecca and I would usually recap it for the readathon, which I really like doing that too, but it still takes a lot of time because you have to sit through the whole trial. So if I'm already sitting through the whole trial, I might as well just be live doing it, So that's the plan. Well, actually, there is no plan yet. But that's the way my mind is working right now. And, we'll see what happens. I'll keep you guys in the loop and I'll talk it out with everybody. But it's just tough to expend as much energy as one does when they're sitting through a trial if there's only a few people in the chat watching. Because like I said, it takes a long time. So yeah, that's the thought behind the possible idea of a plan. And I'm trying, as Dot said, don't burn out. I'm trying not to burn out on y'all. So, and that, that goes along with outside of, doing Something's Off. I also have to research, write, and record and edit for the In Between podcast. I also edit for, Ellen and Joey's show, The Rundown, which happens on Mondays. And I also have Newslight. So I really have to just figure out which one, which thing is like the best use of my time and money. Time equals money. So yeah, all that being said, go like the video if you're here. There's only 9 of you. So I'm really trying to stretch this for a little bit longer so we can get a few more people in here. But we're really going to need to get going with the trial day 9 because it's a 10-hour stream, which means there's going to be a ton of procedural stuff. I know that the defense does not put on a case, as far as I understand it. And they rest. And then there are charging instructions, I believe, jury instructions. And then I think we get to closing arguments in this one, but I'm not quite sure. So the closing arguments, I expect them to be long. We might skip through some of the procedural stuff and go right to the closing arguments. You guys let me know what you want to do, but yeah. Also, I quit smoking and I'm feeling a little frazzled. I just quit today, so it's not like it's probably the worst day, but and I'm so sad. I'm just a mess right now. Look at my favorite cup in the whole world. Somebody dropped it and it broke all the way down here and now it's leaking and I got to find this cup. My sister-in-law got me this cup for Christmas a couple years ago and it's my favorite. Now it's all busted. Um Okay, what else can I tell you about grifty stuff? Become a member. It's fun. Tip if you can, if you like. The QR code's in the top. The Venmo and the Cash App are on the bottom. I put out an Amazon wish list if you feel like shopping for me. That's on the main page under links. And what else can I tell you? I mean, if you don't want to spend any money, which I totally get, and if you can't spend any money, absolutely get it. Please go like, share, subscribe, and comment on the videos because that helps our algorithm. Okay. I think every view on the rewatch helps. I do too. Even if it's just if there's only 10 people here right now, it still helps. I mean, we just got to get the word out because he's getting ready to go and do his appeals process. And I definitely will be covering, whatever he's doing, whatever his team is doing. So, yeah, I've quit before decools. I quit for 15 years. And then I started up again when I was going through a divorce in the middle of a pandemic. So that was dumb, but I did it. And what I use, and I'm waiting for these to be delivered. I found them today. What I used previously, if anyone else is trying to quit, obviously I just quit cold turkey. But I used to have these toothpicks that were soaked in tea tree oil and mint. I know that sounds gross. But it really worked. It really helps me. So I'm waiting for those to be delivered this afternoon and hopefully I'll have them by tomorrow. Yes, I know I've done it before. I can do it again. I'm just feeling like I'm feeling it in my brain. I'm feeling it in my body. I really wish I was playing tennis today. So at least I could get some of that, energy out, but it's not happening. And my face is a little bit pink because I feel flushed. Ay. I'm a mess. Welcome everybody. Yeah, the thing is like when I quit last time, so I quit in I think I was nicotine free for it was almost 15 years. And after about a few months of quitting, I never craved it. I actually hated it. I hated to be around it. I didn't like it when people were smoking around me. And then I went through that stressful period like we all did of the pandemic and, going through a divorce and I just picked one up and it was like one cigarette did it. After 15 years, I had one cigarette and that was it. I was done and I was smoking every day. So it's been 4.5 years that I've been smoking again and I need to quit because I'm 50. I'm pretty athletic and it's hindering my abilities and that bothers me. So let's see. Okay. Next witness said, I quit smoking 4 years ago and I still want a cigarette every single day. I hope I don't feel that way. I still have the urge from time to time. Table tennis. No, I don't play table tennis. I play tennis. Nicotine free. I don't, the thing is, I don't really smoke pot. I don't like it. It hurt. That actually really hurts my lungs too much. I don't like it. So I occasionally, I might vape but I usually do gummies. So one smoke is all it takes. Yeah, the vaping is also really harsh. It feels like to me. So I don't know. I'm just not feeling great. So I want to feel better. I want to have better circulation. I want to have better skin. I want to, all the things. A lot of it's just vanity, but wait, table tennis is a sub for outside. No, not in my opinion anyway. Not the exercise that I get. Plus I don't have a way to play table tennis, but I think of that as ping pong here. But no, I play tennis. And I generally play like 4 or 5 times a week. But my tennis got canceled today and tomorrow. So I'm freaking out a little bit. So I really need to, sorry. Ruby is snoring away in her bed. Okay. Are we ready to do this? There's 7 of you. Might as well get going. Okay, make sure that I'm in the right account so that you guys don't see ads. And I think it's a bunch of procedural stuff right at the top here. Okay. And we're definitely going to speed this up because it's very long. Why is all this crap showing? Okay. I don't mean crap. You know what I mean. Let's see where we start this day. I haven't watched any of this day. I only have some timestamps. Let's see. Oh, that is very sweet of you, Pamabo. You found my cup? Where'd you find my cup? I love this cup so much. I cannot believe it's all cracked. That is very sweet of you. If you would like to send me a cup, I'm not going to say no to a cup. The P.O. box is in our links on the main page. So if you want to do that, that would be lovely of you. Obviously I don't expect it, but it's very sweet. Yeah, I'm not ready for Yamalama Ding Dong either, but he starts off, I think, right at the beginning. Okay, here we go. Speed this up. Speed this up even more. I hate dragging through because it's not very precise on YouTube, so I try to just do sped up, but that sometimes doesn't work very well either. Okay, here we go.
Right. I just assumed Mr. Hill would respond since he's attorney of record also, and I don't even see him this morning, but I put him on the email too, so I thought he would communicate with the court. Okay. All right, thank you.
Is this about his wife falling ill?
Well, we got to get into some issues before we do that. So, all right. So the first few things are this gentleman sitting right here, I need to know, is this young man an attorney? Okay. Okay. Okay.
Why is she so worried about who's sitting at the table?
Well,
I get it, but
table during trial, so you're going to have to sit back on the benches. The other issue that I want to discuss, you both are going to have to sit on the benches. It is not allowed to have non-attorneys who haven't entered an appearance be at the trial counsel table. No, sir. They need to be back.
Get the fuck out.
The other thing is that one of the issues that I wanted to raise to make sure we're all on the same page, and this gentleman right here, I don't know your name, sir. I'm sorry. What's your last name? Evans? All right. Mr. Evans and Mr. Cruz, I know that you needed some information from Charlene Satterfield, who is our court reporter. You asked her when we were on a break, both of you at different times, for information for her to play back things from the record. That's not appropriate. We are in trial. If you need something from the record, it has to go through the court. And I want both of you to understand that it's definitely not acceptable for a paralegal to make a request like that at all. But it's definitely not appropriate for an attorney to do that without going on the record, either making a motion, asking the court, things of that nature. All right. Thank you. All right. I have the jury coming in later. And so this is the time for us to take up some other matters.
Oh, thanks for becoming a new member, Joanna. Sweet of you.
Charges. Mr. Cruz is sending the
Appreciate you.
To Miss Ellis. So she's going to get those compiled. Counsel, what we typically do, good morning, Mr. Hill. What we typically do, and counsel for the state knows this, but counsel for the defense needs to understand this, is we will send you all a copy of the combined charges in one big document online. You'll get that on your email. So hopefully it'll be easy for you to look at it. When we do our charge conference, we'll print the entire thing out. Everybody will have a copy. We go through from front to back. So for Mr.
This always
Hill,
feels to me like
charges,
it's
I always include
small town courtroom, big Atlanta lawyer. She's trying to teach them a lesson.
In every criminal trial.
It's so,
and so all of the definitions, for example, for reasonable doubt, for just as an example, evidence, the burden on the state, things of that nature are always included. You certainly can include those in your charges. If you don't agree with how the court does its typical charges, we'll certainly consider whatever you present. But I just want you to know, if you want to bypass the typical charges that are involved in every criminal trial, you certainly can do so and focus on the charges that are in the indictment. So that's kind of our process. I don't know when we're going to get to that. But I want to make sure you all know that it's going to be a big document for you to look over, and we sort of go through it page by page. All right. Let me ask the state, are there any other issues the state needs to bring up? I want to talk to Mr. Cruz about his timeline in just a second.
Your Honor, we'll have a couple of different motions.
Why is no one using the
we would
microphones?
ask the court to consider this morning
All right.
prior to witnesses
Sure.
taking the witness.
Okay. Mr.
Whichever you would like to do that.
Mr. Cruz, I'll hear from you in terms of your witnesses. We're going to need certainly the information for your WebEx people. And so I'll hear from you in terms of your witnesses, how long you think this is going to take. You may not know, but if you have any idea of where we're going, certainly.
I think we'll be done by noon. I still have to talk with the team to figure out exactly what order we're going to put individuals in.
Okay.
As far as the WebEx information, I provide that to the honorable court now. It's
Okay. We're gonna get. It's one of the reasons why I have the jury coming in a little bit later this morning is we need to get that set up because I didn't have that information yesterday. So if you can actually send that by email right now to Miss Ellis, we're going to get that to Miss Craig, who is in the other county. She's in Oconee County.
Sorry, I'm
Helping
just
handle court out
responding
there.
to a
and we
text
will
there,
get her
guys.
set
I
up
am paying attention though.
caller. She's not local. I advise the honorable court of that. So I need to call just to let her know that.
when we're ready to roll. Sure, absolutely. But if you'll send the emails where we need to send the WebEx, I think we'll put both of them on for the same time. Well, I don't know if we should do that. Let me think. Let me ask you this, Mr. Cruz. Do you already know the
Yeah,
order
exactly.
of
Next
those
witness.
witnesses? Which one's going to go first?
I don't. I need to speak.
Okay,
Ani
all right,
Bub
I'll
did
let
the
you do
same
that.
thing to
Do
Alan
that and let me know.
Jackson.
I think I'm just sort of thinking out loud. I think that's better for
For
the
sure.
WebEx, that we'll try to do it in the order that you're going to call them, so they're not both on the
Which
same WebEx at the same time.
It's so unethical, and
Okay,
they shouldn't be acting
All right,
this
very
way.
good.
It's so stupid.
Any motions you want to present, Mr. Yelman-Chile?
Yes, Your Honor. Thank you. My understanding is, at least in part, we're not sure who all the witnesses are going to be that Mr. Cruz calls, but it is my belief that he intends to recall Detective John Newton, as well as call Detective Mike Tyndall and Kashana
Really?
Armstrong. As it relates to Detective Tyndall, the state would make a motion in limine regarding any testimony about alternative suspects other than Mr. Melton, as has been referenced several times during the trial of this case. In pretrial motions, the state filed a Sadi motion. Mr. Cruz identified only Chris Melton as an alternative suspect that the defense would offer before the jury. Detective Tyndall, I think it's actually Sergeant Tyndall, if I'm recalling correctly, is a law enforcement officer now with the Oglethorpe County Sheriff's Office. At the time, he was with
We
the Athens
arguing
Park
about
County
him
Police Department.
recalling witnesses?
In part,
It's
he
ridiculous.
interviewed
Let him put on a
individual by the
defense.
name of, Stephen Barden, who was a law student at the time, and he also interviewed an individual by the name, I believe, of Anthony Little, who was a resident of Athens Park County at the time. These individuals were interviewed as initial persons of interest, but no evidence was ever developed to link them to the crime. And therefore, in addition, Mr. Cruz hasn't provided notice through in response to the state's Sadi motion, so no evidence of anything related to those two individuals would be relevant, and under a 403 analysis would be confusing and misleading to the jury. So we would make that motion in limine. Also, it's our belief, and obviously we do not know this for sure, that Mr. Cruz may be intending to attempt to question Mr. Newton and Sergeant Tyndall regarding certain phone records for which there is no records custodian who has appeared on the witness list in order to testify to authenticate those records,
Something's
and
happening
no
over there.
notice of intent to introduce the records without a records custodian has been filed. Obviously, we ran into this issue with another witness, which is why the state is making a motion in limine at this time that those records should not, these witnesses do not have the ability to authenticate those records in an appropriate way to lay the foundation for their admissibility. And so those records should not be used as a method
What are
of
the cops
questioning these
doing over
witnesses
there?
or raised as far as their contents in reference to the questioning that Mr. Cruz would do, or even if they're not admitted to evidence, the information in them cannot then be used in the questioning in an effort to introduce hearsay evidence through questioning of witnesses who aren't able to lay the proper foundation for the admission of those records. So those are the motions in limine that I wanted to present, Your Honor. And I know that the way we've split up the cross-examination of possible witnesses that Mr. Cruz may call, if I could have just a moment to consult with Mr. Bolden.
But you were talking about the phone records with regard to the witness. Mr. Cruz is calling Sergeant Tyndall. Is that right?
Sergeant Tyndall and Mr. Newton.
Oh, and Mr. Newton. Okay.
In the recall, I believe there was an attempt the first time that Mr. Newton testified in order to introduce those business records, and the court made a ruling that there was not a proper foundation laid for their admission, and then they could not subsequently be used in the manner that Mr. Cruz was attempting to use them, basically making a motion in limine to continue to adhere to the court's
Hey,
earlier
Amanda.
ruling and
Aw,
prevent that process from playing
babies.
out in the
I
exact
love
same way
babies.
again. And then it's a similar argument with Sergeant Tyndall, because I think that those two
Everyone
witnesses
say
are
thank you
similarly
to
situated,
Amanda. She does our
as it
chapters
relates
and
to
she's
the phone records, and their
amazing.
inability to testify to foundation for admissibility of those records.
Thank you. And you may have a moment, Mr. Bolden. Then I'll hear from you, Mr. Cruz.
Inadmissibility of those records. Why?
Your Honor, Mr. Bolden will be making a motion in limine as well.
Morning, Your Honor.
Morning.
Yes, Your Honor, just to kind of piggyback on what Mr. Yalman-Chile was just discussing, this is specifically as it would relate to John Newton's testimony. One of the things that the state expects that the defense may
Guys,
try to
if you
elicit
have
through its
nothing to
direct
hide in
examination
your
of Mr. Newton is the
investigation
fact that he had a
and your
conversation on January
prosecution,
25th,
then why are you
2001
trying to
with an
bar
individual by the name of
witnesses
Jessica
from
Gann,
testifying?
Gann. Ms. Gann, I believe, well, what's in the report is that she called and spoke with then Detective Newton on that date on the 25th of 2001, January 25th, 2001, that she was at Mexicali Grill over on the east side near Kroger, and she heard some girls in the bathroom talking about law school. They appeared to be drunk. This was at about 9:30, and she thought one of them may have been Miss Baker.
There you
Mr.
go.
Cruz actually referenced that in his opening statement. The state would move to exclude any testimony by Mr. Newton as it relates to his conversation with Ms. Gann. First of all, it would be hearsay. And second of all, even if there were an argument that it is not hearsay, and I think that frankly the analysis should end there. But even if the court were to find that it is not hearsay or it is an exception to hearsay, at this point we would object on grounds under 401 and 403. It's not relevant, and any conceivable relevance is substantially outweighed by the risk of confusing the issues and misleading the jury. And in that regard, I would point out that the uncontroverted evidence at this point, in the form of the testimony of Ms. Lonstein last week, was that Ms. Baker was in the law school library until at least 9:46 when Ms. Baker called her to make sure she got home safely. And so the idea that she could somehow simultaneously be at a Mexican restaurant on the east side under the influence of alcohol is just not borne out by the facts. So the state would object to any testimony, any attempt to elicit testimony from Mr. Newton regarding that conversation.
All right, thank you. Anything else?
No, Your
All
Honor.
right, Mr. Cruz.
Yeah, don't let that in front of the jury. That might sway their
First,
opinion.
First, I'll start with. Good morning.
Good morning.
First, I'll start with Stephen Barden. I do intend to introduce that evidence, Your Honor, and not for the purposes of showing him as an alternative suspect, or for the purposes of showing that they had Mr. Chris Melton and this evidence leading to Mr. Chris Melton. And instead of executing a search warrant on Mr. Melton, the investigators decided to terrorize Mr. Barton and execute a full-blown search warrant on his house, obviously because he had nothing to do with Ms. Baker's murder, turning up no evidence of a murder. But these same actions were not taken with Mr. Melton. So the sole purpose of that testimony would be simply to, as we stated in open, as we maintained this entire trial, just to show that this investigation was not thorough. It was directed away from Mr. Melton at every twist or turn. In regards to Mr. Newton's testimony, in regards to Jessica Gann, as far as hearsay, we're not offering Jessica Gann's statements for the sole purpose of the truth of the matter asserted. Similar to the questions we asked about Ms. Shauna Armstrong, we're offering information about Ms. Gann, again, to show that the investigation was not thorough, the early investigation. Law enforcement was aware of this information. They did not provide Ms. Gann with a photograph of Ms. Baker. They did not do any type of, I don't want to say a lineup, but they did nothing to follow up on the information with Ms. Gann. They got the information, they just ignored it and moved on. And that information also impeaches the state's position. The state's position is simply that because Mr. Faust's DNA is present, that means he's responsible for every single count of the indictment. One piece of evidence they have not shown, they haven't presented anything showing where Ms. Baker was the night before her death outside of the library. And in regards to the timepiece, I think that's more appropriate for cross-examination as opposed to a motion to limit. And the reason why, Your Honor, is the state has defended multiple witnesses on their time discrepancies, even time discrepancies that occurred closer to the crime. I believe Ms. Gann might have been interviewed, I believe it was 7 days.
Apparently not, Amanda.
I believe the state made this argument in regards to a particular witness. I can't remember the witness, but if she wants to make an approximate time, hey, I believe it was 9:30, maybe 10 o'clock. I don't know what she said because we only have the report, but I believe it was around 9:30. That's something they could flesh out with Detective Newton during cross-examination, Your Honor. So those are the only two motion to limit we would seek to address with the Honorable Court. In regards to the phone records, the Honorable Court knows my position with the records. I respect the Honorable Court's ruling. I think you've made it clear that we are not to present any phone records of anybody at any time. So that's the issue that Honorable Court ruled in the state's favor on. So we disagree, but we follow the Honorable Court's ruling.
All right, thank you, Mr.
Why?
Cruz. I'll start with the phone records. The issue with the phone records was not necessarily a blanket instruction to prohibit testimony of phone records. The ruling was based on the lack of defense counsel's, for whatever reason, lack of providing the proper witnesses to bring those phone records in. And without the proper witnesses subpoenaed by the state, phone records are not allowed under law. And so that's the ruling I made. I want to make it clear for the record that the court's ruling was not a blanket. The defense cannot bring in phone records. Certainly, there might have been, if you had subpoenaed the proper people to bring them in, we could have had another hearing as to whether they were relevant. I mean, I'm not making a comment that they would necessarily be admissible, but just the ability to talk about them is based on the lack of ability to produce the proper foundation. I know we argued that at the bench, but I want to make that clear.
Can I respond to that?
You may.
The state, we had a hearing on this. I asked for out-of-state subpoenas regarding the phone records.
Amanda says,
I believe, I can't think of other companies, but the companies were out of business. They sent me emails.
were they
saying
able
that
to
this
differentiate it
they did
if
not
it was
have a way to secure
semen-based
those
DNA or
records. The state has
saliva?
explained to the Honorable Court
I remember
that
them
they would-
speaking about
they
it, but I
would,
forget the answer. It
would,
depends on
look
which
for
one
proper
you're
words. I don't
talking
have the
about.
charges. They would agree that for foundation purposes,
There
the charge
was
missile. They said they would object on hearsay grounds, things of that nature. But our argument is that records
anal,
aren't hearsay because they are computer-generated records as
buccal,
opposed to a
and
statement by a
vaginal
person. Just to
swabs
let it
done.
Well, let's talk about that because we did have a hearing with regard to those issues. There are a lot of phone records that we were sort of talking about at the time. So let me let the state respond. We can talk about that. Go ahead.
I'll be happy to respond, Your Honor. That hearing did occur at that time.
Who
we had
doesn't allow
been
phone records
for,
in?
several weeks, I believe, attempting to discuss and lock down stipulations with Mr. Cruz, and it was the state's belief at that time that we were going to be in a position
God,
where Mr.
they
Cruz
act like
was
he's a
agreeing to
petulant
stipulate as to the
child, and it
foundation
drives
for
me
certain crime lab
nuts.
reports, and in exchange, the state would be willing to stipulate to certain phone records and also crime lab reports from North Carolina in the form of some mitochondrial DNA analysis. However, Mr. Cruz never gave the state a response despite repeated requests to give us an answer as to whether or not we had stipulations. I drafted a list of proposed stipulations and I gave them to Mr. Cruz in the form of a physical document, I believe on the first day of jury selection. After reviewing that document and consulting with Mr. Faust, Mr. Cruz informed the state that at Mr. Faust's direction, the defense was refusing to stipulate to anything. So an offer was made and denied by the defense. And at that point, there were no stipulations, and the state has endeavored to call the appropriate witnesses to admit the evidence that it intended to admit via stipulation, and it was certainly something that was available to the defense as well. But as the court noted, for whatever reason, those witnesses haven't been present in order to lay the foundation. So that's the context in which stipulations were discussed and then refused by the defense.
All right, thank you. Anything further, Mr. Cruz, based on Mr. Yelman-Chili's comment?
No, that's accurate.
Okay.
I was we were free
Okay.
stipulation by Ms. Allen, so
All
correct.
right, thank you, sir. So I think based on that, and I do remember certainly the hearing, I can go through and look at my notes. They aren't in front of me at the moment in the order that the court signed. But I would just say, I mean, I'm going to grant your motion with regard to the phone records, Mr. Yellman Shelley. I think that is appropriate legally at this point. If a stipulation is not entered, as was announced in court, that you all would be able to work that out, the court would have had to know that in order to specialize or set a special time, I should say, to hear the rest of your motion, Mr. Cruz, to decide whether your motion was appropriate and whether what you were asking for could be granted. And that hasn't been done. I can't do it certainly in the middle of trial. So I'm going to grant your motion with regard to the phone records. With regard to any testimony from Mr. Newton, with regard to a witness that you wanted to call, Jessica Gann, let me ask you this so I'm clear on what you're saying. Well, let me just ask you, what is your position on the state's objection about hearsay? Yes, I mean, they've objected on other grounds as well, but what about the
It goes
hearsay?
to notice. That's my response. It's not hearsay because it goes to notice. That law enforcement was on notice about this information and they didn't follow up on it. We're not offering it for the truth of the matter. We're offering it to show law enforcement, which is one of our multiple defenses in this case. I think a big part of the state's case is that law enforcement had information that they just failed to follow up on.
Let's deal with this DNA question from Amanda. It's really important. I think that this is sort of a more nuanced answer, and I think it's one of the biggest arguments in this case. So it really depends on, I think, whose side you believe. The state argued that the DNA that was found was seminal fluid. But the defense obviously completely disagrees with that, and that because, and I'm gonna side with the defense here because they didn't have a confirmatory test. They didn't use a confirmatory test. It was a presumptive test. So let me just grab my notes. Hold on. So the state is basing its conclusions on the process the GBI used to extract the DNA. It's known as differential extraction. So the process when the GBI data or DNA analyst, Zykira Sims, do you remember her? She was really beautiful. I think she was wearing glasses. She tested the swabs. She used for the swab. She used chemical processes designed to separate the DNA into two distinct batches. Fraction, that's the non-sperm fraction. And that fraction 1, that's the non-sperm fraction, was designed to hold standard epithelial, which would be skin/surface cells. Fraction 2 would be the sperm fraction. And that's the oral swab and that was the mislabeled vaginal swab, right? So the argument, because Edrick's DNA was isolated in the fraction chemically designated to extract sperm, the prosecution argued to the jury that his DNA was deposited via seminal fluid during the rape and aggravated sodomy. There was no sperm found in her rectum. It was only, for the state to say sperm, it was only found vaginally. So, but the issue here is we go back to the iodine test and the lab in California saying that this swab was mislabeled. And that can't be conclusive. They can't confirm that. They can't conclude that. They can only posit that. But they're acting as if it is factual. And that's the problem here, I think, in front of the defense. The defense isn't reading these nuances for some reason. So Ahmad Cruz, he aggressively attacked this, but I don't think the jury understood it. I think that's a big problem here. He said that the state's assumption that fraction 2 automatically meant sperm, pointing to a glare. It was pointing toward that non-confirming science, right? So no modern sperm test. During cross-examination, Zykira Sims was forced to admit she did not perform a confirmatory chemical test for the actual physical presence of sperm. She only tested for DNA. The 2001 tests were negative, FYI. Cruz reminded the jury of the testimony from earlier in the trial. So from 2001, GBI forensic biologist Jennifer Corsi. In 2001, the GBI did test those exact swabs for semen and spermatozoa, and the results were completely negative. Completely negative. And then Sims also admitted on the stand that differential extraction is not always perfect. If a sample is complex or degraded, maybe a sample that's 24 years old, there can be carryover, meaning saliva, blood, or skin cells can accidentally bleed into the sperm fraction. So bottom line here is the state is telling this jury The DNA came from sperm, and it's concrete, and it's to support the charges of rape and sodomy. The problem here, the way that I'm seeing this is akin to in the Karen Reed trial, when the 2:27 a.m. search came up on Jennifer McCabe's phone, and she said she didn't make it at that time. And so they had Celebrite come in and rewrite their software in order to make what Jennifer McCabe was saying true. So they basically fudged the science. And that's kind of what happened here. I'm not suggesting that these scientists fudged the science, but they chose these tests that are junk. This iodine test is junk. And then just the very idea that the GBI DNA analyst did not, that's the only confirmatory here, did not perform a confirmatory chemical test for actual physical presence of sperm. So we don't actually know. And for 24 years, that swab was labeled as a buccal swab, which would mean that it was from the mouth. So this entire case, they just put this man away for 2 life sentences without parole plus 45 on this one piece of evidence that is not conclusive, and it doesn't confirm anything. The tech exists and she did not use it. I mean, she has to answer to her overlords. So if the GBI is saying, hey, will you test this? Hey, will you test this? Like, that's what we're asking you to test. I do wish, I'll be honest here. I think everybody on the jury is probably confused about the DNA stuff. They should be. But the problem is that they see how confident the prosecution is in their evidence, and they're going to believe them, The other issue here is that the defense doesn't put on a case. And I really do think, I think at this point, I don't want to speak for Ahmaud Cruz, but I think at this point they realize they've already lost because of the way the court is treating them. And so I think that they know they've already lost. So they're going to have to start gearing up for the appeal. I still think they should have put on an expert or two. I think the experts could have actually changed the jury's mind, but I think it must be a very difficult decision to make when you're in the heat of the moment and in a hostile court, All right, let's get back to it. We are still arguing about phone records. Yeah, D Cool says, there's so much of this case that I just must not be smart enough to understand. I don't think that's true. I think you're very smart. Because this whole trial has been about Chris. In my opinion, that should have led to a hung jury at least. That I agree with completely. And there's enough evidence. But the problem is that then you have to take that second layer of these kind of trials and cases, and you have to bring in the confirmation and personal bias of the jury. And unfortunately, this jury doesn't represent Edrick Faust. There are only 2 people of color on the jury, as far as we've been told. And so I think that in this area of the country, it might be easy for them to be like, yeah, I'm sure this guy did it. He's black. I can't get past the jury makeup,
This goes to notice that law enforcement was aware of this fact and they didn't follow up.
Thank you, sir. I think at this point, what the law would require, Mr. Cruz, is that if the defense's argument is that these statements that certainly I would say at this point would confuse the jury about anything that may have happened at a Mexican restaurant with a person's statements who have not been elicited in court.
Confuse the jury,
I
or
certainly would say that under
give them other options.
Confusion of the issues and misleading the jury. I think that's certainly a problem. But I would say that at this point, Mr. Cruz, the defense would have to provide evidence to what you've just stated. I mean, a blanket statement that you're making that if law enforcement had followed up with Jessica Gann, this case would have been over 20 years ago, that's a pretty spectacular statement. And in order to ask the court to admit,
how is that a spectacular
in lieu of
statement?
that comment, the defense has to provide the court some evidence that would in fact have been true. And
Oh,
without
fuck
evidence,
off,
that
lady,
testimony that
come
you are seeking
on.
to elicit, certainly I would say falls under the category of misleading the jury, of confusion of the issues. And it really does come close to that line that we have been discussing this entire time, which is the order that there are to be no statements by witnesses about other suspects other than Chris Melton, which you properly gave notice to the state for. So, you certainly can respond to what I've said, and then we're going to kind of move on, but go ahead.
So 2 things.
She's going to nitpick this so much that because Ahmaud Cruz just said, had they interviewed this woman, had they done their due diligence and cleared this tip 25 years ago, we may not be here today. That is a true fucking statement. Now, it's an if statement, right? So the idea that she's like, this is extraordinary. How could you say this? Blah, blah, blah. How can you say this? You have to show me proof that if this happened, it would have been clear. Come on, lady. She knows what he's saying. This is so stupid. She is such an asshole. God, I'm grumpy today.
My statement, I think I may have said it wrong to take it out of context. So my statement wasn't, or should not have been, forgive me if I said it this way, isn't that, hey, if they solely would have talked to Jessica again, this case would have been resolved. I believe I said it the wrong way. What I was saying is, if law enforcement would have followed up on all leads, this case would have been resolved.
Yes.
As far as the 403 ruling, Your Honor, the state didn't object on the basis of 403. I understand the court could make any ruling that it deems appropriate, but the state did not object on 403 grounds. The state objected on hearsay grounds, and we provided our response to the hearsay. I would like the opportunity to provide.
Malden's getting all pissy over here.
Using the issues for the jury.
You certainly can. I thought Mr. Bolden did make a 403 argument, and that's I'll let you respond regardless. But I think he did. But the court has an obligation, regardless of whether the state or the defense talks about 403. The court has an obligation to respond to 403. So you certainly can respond.
Sure. So in regards to 403, as far as confusing the issues, this statement from Detective Newton wouldn't require a mini trial to determine facts of issue. It's simply a building block on the facts in this case.
Akasha, you are absolutely right. The only thing they have on this guy is inconclusive DNA. That's it. They have solid conclusive DNA on Chris Melton, however, and Chris Melton's DNA happens to be in the, it's so hard to talk about this. Chris Melton's DNA, his sperm, happens to be found on Tara's body in the places where she was sexually assaulted, brutally sexually assaulted. So how can they choose between a gray area, inconclusive piece of DNA and actual DNA from a guy who said originally he hadn't had sex with her in 10 days, who was, for all intents and purposes, sort of on the outs. They were having outs of their relationship, and who has a weak ass alibi from his parents. I mean, how's Edrick Faust supposed to come up with an alibi 24 years later when he doesn't even know who this person is and doesn't even didn't live in the neighborhood? He lived on the other side of the tracks, if you will. And it's ludicrous. It's ludicrous that a jury in 2026 just convicted a man on that evidence. They don't have a solid eyewitness sighting of Edrick Faust in the neighborhood at the time. They do have a white dude running away from Tara's apartment at the time when this could have happened. They do have Chris Melton's DNA all over the place, all over the murder weapon, all over the murder victim's body. They do have a crime scene that was locked from the inside and there is no forced entry, which means she had to have known the person or let them in. All of those things point away from Edrick Faust. There is something wrong with this jury. I'm just going to go ahead and say that. Drainage, my ass. Oh, that's gross. I shouldn't have said that. Yeah, that's the problem, is like, you can say drainage all day, but how did those bruises get there? In the same place where there was drainage. D. Cool said, for real though, the 10 or even 6 days with no contact and his DNA being in her should have closed the case 25 years ago. Abso-fucking-lutely. And his hands. Don't forget his hands. Yep, Akasha, what Chris Melton's hands look like. His DNA is supposed to be there, but his DNA isn't supposed to be there in a certain time period. I mean, the idea that Liz Bigham asked him the question 10 times and he only changed his answer once after she pressured him 10 times is so fucked up. And yeah, exactly, Amanda. Poor Tara, RIP, and her killer is still out there. And this poor man is possibly going to be sitting in prison for the rest of his life unless some of us do something about it.
Support our position. I don't think that one fact in the, I think we're on the 9th day of evidence, maybe? We're on the 10th day of evidence. Started last minute, if I'm not mistaken. That one fact out of 10 days of evidence, I don't believe that would confuse the jury where they say, hey, we don't know what the heck is going on in this case. I can't believe Jessica Gann said that she saw Miss Baker. So that would be my response. I do not believe that one fact would confuse the jury, and I'm not sure. Did you say waste of time also? Or
I did not.
You said confusion of the issues in one word.
Misleading the jury.
And my argument would be the same. I don't, out of 10 days of testimony, and of course, none of the court has all the wisdom. I don't believe that that one fact would mislead the jury to making a decision in regards to the indicted charge where they say, you know, we have this fact. Now we don't know if Mr. Faust is innocent or guilty because of this one fact. So I ask the court to reconsider its ruling on the 403.
All right, thank you, Mr. Cruz. I mean, I think the argument you've just made supports the court's conclusion that any evidence regarding this Jessica Gann person, well, first of all, it certainly sounds like you're saying, I understand what you're saying, Mr. Cruz, that you're not offering it for the truth of the matter, but I think there's an argument to be made that you are, but I'm not finding that it's relevant. I think at this point, given the comments that both counsel has made, it would be incumbent upon the defense to provide evidence as to why any testimony by Jessica Gann would be relevant. And so I'm going to grant the motion. I'm going to find that it is not relevant. It is hearsay, and there's no exception to overcome the hearsay. Under 403, I certainly do think at this point, bringing in another person to suggest evidence that is not supported is a very
I wish we could see the
misleading the jury and confusion of the issues. And so
computer
under 403,
screens of the
I'm gonna grant the
prosecutors.
motion as well that Mr. Bolden has made. There will be no testimony allowed to be elicited from Mr. Newton about Jessica Gann. No testimony elicited from Sergeant Tyndall regarding contents of phone records unless you can present a witness that can lay the proper foundation. Let's make this clear though. I want to talk about this. Is there an objection from the state? Let's do this right now about Mr. Cruz asking Sergeant Tyndall whether he was able to get phone records.
And that's what I was responding first. He laid the foundation for the phone records.
Sure.
What order he obtained via recognizing the phone records via stating that,
Right,
those phone,
right.
that they didn't appear to be officers. So he laid the foundation for the records that you received.
I remember that. I have that in my notes. But let's just get this out now so we're not having any,
I do not believe that there is anything wrong with asking Sergeant Tyndall if he obtained phone records. However, whether the police officer got phone records back as part of his
When
court
you're
order is
fighting
not the proper
over-
foundation for admissibility of the
When you're fighting over these little nitpicky things, foundation about phone records and, when you're trying to keep witness testimony out, meaning the tip that came into police, when you're trying to keep phone records out, when you're trying to convince the lead suspect of 25 years that he actually had sex with his girlfriend 6 days prior to her murder, not 10 days, this is shady as fuck. This is so shady. I wish that this jury had put themselves in Edrick's shoes for a minute. Like, I wonder what would have happened if Edrick Faust was a white dude. Was just like, I don't know, a poor white dude. What would the jury have done? I wish there was a way for us to test it,
those phone records.
I understand.
And so that's what our objection is to the
But I'm still in the
content. The fact that he did in fact seek a court order, that the phone records were provided, are things that I think are appropriate questions that can be answered. It's just that any contents of the phone records cannot be asked about without the appropriate foundation witnesses, as the court's already articulated.
All right, thank you. So I want to make sure, Mr. Cruz, do you have anything else you want to say about that or any questions for the court? I mean, I do think that's right. And Sergeant Lieutenant Tyndall has already testified, as you said, about those records. They are in my notes. Again, I don't have it in front of me, but was Newton? Yes, ma'am. Yes, ma'am. Sure. Grab the microphone again.
Newton
Right.
was
It was Officer Newton.
I don't believe Tyndale was testified at this moment.
That's right. It was Officer Newton. Okay, so let me just make sure we're clear. And I do recall the testimony. It was Officer Newton. I mean, Mr. Newton, former Officer Newton. Are you intending to ask Sergeant Tyndall about phone records as well, obtaining phone records?
I'm only going to ask Sergeant Tyndall about things under court permits. From what I understand right now, that is not permitted, so no, ma'am.
Well, that's why we're having this discussion. I mean, I think the question as to whether an officer in his or her investigation received phone records is certainly a permissible question. And I agree with the state's characterization of that as being admissible. I think it's the contents and the admissibility of what's in the records that's at issue. So let's just flesh this out now, make sure you're well.
So the content.
Same, Amanda. Me too. I'm
that's
sure
what's
everyone
important to
here
us,
would
because
have
I
done
think
the
it
same
shows and
thing.
will establish the nature of Mr. Melton and Ms. Baker's relationship up until the day before her death. If the honorable court's ruling is that we are not to get into the contents of the phone records, and of course we put our response to the state's hearsay objection in regards to the phone records, I won't go into that, Your Honor. But if the honorable court is saying, hey, my ruling is that you cannot get into the contents, you cannot talk about the phone records with the witness, I won't get into that.
All right, thank you, sir. All right, so I'm not changing my ruling unless I'm presented with some other piece of information that is appropriate for the court to change its position without the proper foundation to be laid with regard to the contents of the phone records. They're not admissible in terms of the content.
Well, I do want to say this just to make it clear for the record. The foundation was laid by Mr. Newton. I think the disagreement between me and the state is saying it's hearsay, and I'm saying that it's non-hearsay because they're computer-generated records. That's the only disagreement, and of course, the honorable court issued its order on that.
Sure.
Just wanted to make that information clear.
All right, thank you. So it doesn't overcome the hearsay because there does need to be a foundation laid in terms of the contents of the record. And so of the records. I'm not going to change my order on that. A foundation has to be laid. They are hearsay. And unless the witness is a custodian of those business records and testify to them as would be required under law, I am going to rule that the contents are not admissible. The questions about whether an officer received phone records is an admissible question. Mr. Yelmichel, did you want to add something before we finish this phone records conversation?
Just briefly, Your Honor, I'm sorry, I should have mentioned this before. We would, although it's perfectly fine as from the state's perspective for Mr. Cruz to ask about whether or not Sergeant Tyndall or Mr. Newton received phone records, we would say that any affidavits that were submitted by the law enforcement officers in order to receive the court orders to get the phone records and the court orders themselves, I don't think are admissible as evidence, as substantive evidence in the case. Just the questions are appropriate, but I don't think those documents, as far as the affidavit, would be admissible and would be able to be submitted to the jury.
Okay, and tell me why you don't think they're admissible. What would be your argument?
Well, Your Honor, those affidavits are within them going to necessarily contain some hearsay information, since they are, the officer's statement and affidavits for purposes of receiving court orders or search warrants are not limited by the rules of hearsay when they're being submitted to the judge. Now, if there were certain portions of them that serve to contradict testimony that the witness gave about things they did or did not do, then they may be admissible for the limited purpose of impeachment on those issues. But just simply tendering a law enforcement officer's affidavit, I do believe would contain hearsay statements within it, and also contain their opinions on certain things and various other things that wouldn't necessarily be admissible in the context of a trial before a jury, although they would be appropriate for the purpose of having obtained the court order to begin with.
All right, thank you. Mr. Cruz, have you heard on that?
No, ma'am.
All right. Then I think that's right. I mean, that's, I think, a correct statement of the law. I would say, however, in the same vein as questions about did you obtain phone records is an admissible question. I think certainly, and I'm not telling you how to do your examination, but if you chose to ask the officer, did you seek a search warrant for phone records, that is an admissible question. And unless you want to be heard on that, Mr. Yelman Shelley, I want to make sure sort of we're clear that there are certain things you certainly can ask law enforcement about their
You lose sound?
investigation, and asking for a search warrant and did they go seek one is an appropriate question. I think the context of what they received would probably not overcome a hearsay objection. If you feel otherwise at the moment, we can take it up outside the presence of the jury. All right. With Shauna Armstrong, or is it Keyshawn Armstrong? Keyshauna. All right. There was a motion in limine regarding any comment. about
Everybody
another
else
person.
okay on
I forget
sound?
the name. Was that? Hold on just a minute. I want to make sure I've written this down right. Did you make a motion about Ms. Armstrong? Was that you, Mr.?
Jesus,
State
she's
has
a
any motion in
dumbass.
regards to Ms. Armstrong.
I wrote down Ms. Armstrong. I thought there was something about Mr. Another person who they did not.
There-
You didn't bring evidence. Bolden, is that correct? Or Bolton?
I hope not.
I'm sorry. Was it Bolton? But
Barton.
Barton. Sorry, Barton. Okay. I'm not sure I wrote it down. You were expecting that information to come through Ms. Armstrong's testimony?
Well, no, Judge, it was Sergeant Tyndall.
That was Sergeant Tyndall. Okay.
Yeah, it would be Mr.
Right.
Barden and then also an individual by the name of Anthony Little. These would be two people that were considered persons of interest at the time. However, no information was developed to link them to the crime. And it was our belief, or at least we thought it might be a possibility, that Mr. Cruz is attempting to elicit
Okay.
testimony regarding
Thank
those
you, guys.
individuals from Sergeant Tyndall or Mr. Newton. I mean, just our motion limiting has to do with those two individuals just being mentioned in any way, since Mr. Cruz did not identify them as individuals he intended to raise as alternative suspects in response to pretrial motions hearings.
All right. Thank you. All right. I don't know why I wrote Ms. Armstrong's name down, and we have to get her WebEx information. That may be why I wrote it down. Fantastic. All right. Mr. Cruz, do you care to respond any further with regard to the remainder of the state's motion in limine as it concerns any person by the name of Baden and Little last names?
Baden and Little.
Baden and Little. They were just referring to two. Barden? I'm not going to get it right. Barden. Sorry. Barden.
I believe I put that information on the record for the record opposition. That nothing changed from my
Okay. All right. Thank you. I'm going to grant your motion. It does violate the study motion the court has granted in previous hearings and that we have been discussing throughout the course of this trial. And so I'm going to grant your motion. There will be no testimony about anybody by the last name of Barden and Little through Sergeant Tyndall or Mr. Newton. It would violate the court's previous ruling. So, all right.
Your Honor, I hate to jump in on that. There was another piece of this that I think because Mr. Yalman and I are kind of splitting up potential defense witnesses today. Mr. Newton also spoke with an individual at the Clark County Jail back in March of 2001. That person.
I really wish
other
they'd put
names
on a
of people
case.
who were allegedly making admissions or whatever about being involved in this crime. The inmate with whom Detective Newton at the time spoke, her name is Melinda Thomas. The information she provided is secondhand hearsay about what some other people would have told her. These are not as it relates to Mr. Little or Mr. Barden, but under the same theory, the state would ask that any testimony about these other alternate perpetrators or potential.
Yeah,
alternate
I agree,
perpetrators also be
Pamabo.
excluded.
All right. Thank you. Mr. Cruz.
Just for clarity, Your Honor, I may have said it wrong or misspoken.
Okay.
But these individuals, I'm not saying they committed a crime. I understand the state's alternative perpetrator.
And from what I've heard, just from folks who were in the courtroom, I think from Melanie's Cupcakes and other folks, the lawmakers who passed the Coleman-Baker Act, which is this is the first case that fell under that act, and it's named after Tara Baker, were also sitting in the courtroom and sitting right next to the jury as well. So there was a huge amount of pressure on the jury. I'm still not excusing what they did. I don't want to excuse it because any reasonable human being, if you couldn't see what Edrick Faust looked like, any reasonable human being, no, that's not even true. It doesn't matter what he looks like. Any reasonable human being sitting there and listening to this evidence should understand that the only concrete evidence, physical evidence that they have for the killer on Tara Baker's body comes from Chris Melton, regardless of whether he has a weak ass alibi or not. The only person whose physical, personal DNA evidence is on the murder victim's body is Chris Melton, and his evidence of his body is on the murder weapon. I mean, they're trying to D-Cool's. This is the way it's been this whole trial. You know that. You've been watching it with me. They are trying to put on a third party defense, and she's not allowing them to. I mean, that's what it's coming down to. A lot of this is coming down to, procedural stuff that they're getting hung up on, which kind of sucks. But no, they're not. They haven't been able to put on a case. And Ahmad Cruz is right. This court is stacked against them, and that's unfair.
Ruling. I'm not saying any of these individuals committed a crime. So I may have explained it wrong. The purpose of Steve Barden is to show the investigative steps. It has nothing. Our position is firm. Chris Melton committed this crime. We're not saying anybody else committed it. So if I say something that sounds like I'm saying, Judge, we want to point the finger at this person, we want to point the finger at that person, I'm just misstating. That is not what I'm saying. anything that we're seeking to bring in at this point in our case in chief is to show the failures of the investigation. They have nothing to do with whether a person committed a crime. They have nothing to do with hearsay. It's just whether did you have notice of this fact? Did you follow up on this fact? If not, why? That's our entire theory with the witnesses. As far as
there's nothing wrong with
the
that.
Witness, Mr. Bowden is speaking about. I just want to make sure we're talking about the same witness. May I see the? If there is one I wanted to discuss with.
All right.
Mr. So in fact, you intend to speak about Ms. Thomas. I wasn't going to refer to her by name. I was just going to say, did he speak to an inmate? And the purpose of this testimony is just to show, and I'll put it this way. It would be in serve rebuttal if the state has a rebuttal to our defense. So we wouldn't get into that information with Mr. Newton in our case in chief. But if there's rebuttal, this testimony will become relevant.
I'm assuming that these arguments are the reason why they didn't put on a case, because she's not allowing them to put on a case.
In regards to the evidence that we present.
It's crazy. It's so crazy.
I'm not really sure I understand what you're asking, Mr. Cruz, about the rebuttal evidence, but I do want to respond.
Do you guys
to
not
your,
speak the same language,
your
or
arguments that
because I understood it, and I'm not a
relate to
fucking
the
lawyer
states.
or a judge.
I'm actually looking for the order that I wrote with regard to this whole issue. Your responses to the state's motion in limine with regard to Mr. Barden, Mr. Little, this unknown person at the jail.
We don't have anything from Mr. Little. We didn't intend to elicit any testimony about Mr.
Okay. But I'm going to mention this person in general because they all relate to the same thing. I understand certainly what the defense is saying about their position that the state law enforcement did not investigate this case properly. And I understand what you're saying about notice, and that is those positions are the reason that the statements about other persons should be properly admitted. I understand what you're saying. The problem with that legally is this. The defense is asking for the court to allow it to go to admit those statements under that theory. And in doing so, that would bypass the court's order that it has already granted the state, which is that if there were any alternative suspects that were to be discussed at trial properly, the defense had to provide the proper notice, which would then allow the court to set a.
That is not what he's trying to do. He just said that. He is not trying to present any other alternative witnesses. He just said, we believe Chris Melton did this. We want to question these witnesses about how the investigation was handled and if it was handled properly. This reminds me again of, Bev Cannoni turning down in the second trial when she turned down, I don't even think they did a voir dire of it. They were going to have a witness come in who was, I believe I think he was ex-FBI. And they were going to have him come in and explain to the jury what a good investigation, what a good crime scene forensic, how you deal with a crime scene, how you interview witnesses, how you do all the things you should be doing in an investigation. And she didn't allow that in. There's only one reason not to not allow that in. And that's because it would be really, really good argument for the defense. And when I see judges Easterly, that's who it was, not Easter Day. Was it Easter Day? No, it was Easterly. Yeah. Mike Easter. We're all wrong. Mike Easter. I think Pamaba might be right, actually. Yeah. When I see this, it to me, and it may not be true, but what I see is a judge putting her thumb on the scale. And that is not the defense. A defendant is allowed to put on a case. They're allowed to defend themselves. And Edrick Faust isn't being allowed to defend himself. I mean, let's hope they have a decent appeal argument equals. I mean, if it goes to an appeals court here in Georgia, who knows? Who knows? I mean, appeals are so difficult. They're so difficult. I mean, I'm working with the law team right now for Pamela Smart, and the state of New Hampshire is trying to completely dismiss the 5-point habeas that we submitted, or that her lawyer submitted and I helped with. And to hear that they're disregarding the arguments that we made when they are based in fact and evidence and scientific study, man, it's frustrating. It's frustrating to see that happen to somebody who deserves to be heard.
Hearing, so that we can determine whether the statements being offered.
Hey, Jody. Oh, you were with Ellen and Daisy. I understand. I get it.
With regard to a hearsay objection, particularly whether they would be admissible because of relevance. And so just by stating that we're asking to admit those statements under a different theory, it's not. Hold on.
So we talked about the Innocence Project here in one of the other episodes, and I'll just try to recap a little bit for you. The Innocence Project there are several Innocence Projects. The main one, the big one, is in New York, and they are inundated. They probably have a wait list that's like a decade long, unfortunately. The other Innocence Projects are usually done by state or region, and generally they only take on cases that deal with their region. Now, I would assume there's an Innocence Project here in Georgia. I feel like the Innocence Project was involved in that documentary. Wasn't that documentary about the Georgia prisons? I can't think of the name of it right now. I think it was nominated for an Oscar. It was an amazing documentary about the prisoners who they were able to sneak cameras into the prison, and they exposed corruption and murder within the prison system within the prison from the prison guards. And I think that took place in Georgia. It was either Georgia or Alabama. I can't remember. But the Innocence Project, no matter where they are, no matter whether it's regional or the major one, they are backed up. They have a wait list in most cases. Oh, I'm sorry. Yawn just took me over. It doesn't go straight to the Supreme Court. The next appeal will go up to a higher court, maybe a state Supreme Court here. I'm not sure if they'll do it through a superior court or a state's Supreme Court. I'm not really sure, but it won't go up to the United States Supreme Court until they've exhausted everything, until and if they decide to do that. Yeah. Is it called the Alabama Solution? Was that what it was called? I think the Innocence Project was involved in that. So for instance, Darlie Routier, who is a woman who's been on death row since the late 90s she was charged and convicted of murdering two of her children brutally. I have, for most of my life, understood that Darlie was actually innocent of that crime. And they do have DNA in her case, which they are just starting to test. I know the Innocence Project is working on Darlie's case right now, but this is she's been on death row for 28 years, I think, something like that. So it took them a really long time to get involved. When they were smaller, right after the O.J. Simpson trial, when Barry Scheck worked on O.J.'s team, Barry Scheck then created the Innocence Project after that. When they were smaller, they could take on a lot more of these cases, but now they're huge and there's not a ton of funding. So the Innocence Project is involved in a case like Darlie Routier. This case, it's going to take a while for it to move up. I mean, the Innocence Project won't even touch Pam Smart's case because there's no DNA. This would be a great case for the Innocence Project to take on. And maybe if a bunch of people write letters, then we can get some more attention on this. I don't want to make it sound like there's no way, but it just takes so long. It takes long for them to even get a letter through to the Innocence Project. But, I think that once we're through covering this trial, I'm going to try to reach out to Ahmad Cruz and his team and see if we can get some ideas of how to help and maybe have him on the show. Once, Edrick is settled in the prison that he's moving to, we might be able to have, a phone conversation with him. We'll figure it out. But for right now, I think the most important thing is to share his story, because I think the more people understand what actually happened in this courtroom, very similar to what happened with Karen Reed, the more people understand this story, the more people will probably be outraged, and then there will be more eyes on it and more money will be raised for the legal defense, and they can actually put up a big fight. So that's what I would say.
It is not appropriate for the court to allow that, because what that does is circumvent the prior order. They have to be done in conjunction. And so if the defense wanted to elicit testimony about other suspects for the purpose that you're asking for them to be elicited, notice under
we're definitely not going to get through all of this today.
In order for the court to have heard, in order for the state to have gotten the required notice, and in order for the court to have set a hearing date in order to flesh this out, and that hasn't been done. And so I understand what you're saying, but it is not appropriate to circumvent the order by saying, well, it's just under another theory. That motion was not filed by the defense for whatever reason, and I'm not commenting on that. That may certainly be a strategic moment on the defense's part, and but it hasn't been done. And because the proper notice hasn't been done, in order for the court to make a ruling that, regardless of the state's feelings about those statements, regardless of any other legal objection that we've discussed in those hearings, those statements would be proper. The court hasn't had that opportunity because notice wasn't filed. So I'm going to grant the state's motion based on those for those reasons. All right, but I wanted to kind of make that clear. All right. let me start again. Anything else we need to take up before the jury comes back in?
No, Your Honor.
Okay. Mr. Cruz, is there anything else we need to talk about before?
Well, based on the rulings, I would like 10 minutes to talk to everybody. So we have to figure out what.
Absolutely. So I think what we're going to do is this. We have your information for WebEx. We're going to go ahead and get that set up. I'm going to give you all till 10:20. Right. So that's about 25 minutes. I'll be back on the bench at 10:20, and then we'll get started. All right. We'll be in recess until then. Thank you.
Your Honor,
By the
I
way-
speak with Mr. Faust too, so he'll need to be a part of that discussion. Can we make that happen? Mr. Faust will need to be a part of that discussion as well.
We can absolutely remain here. No problem.
By the way, I don't know. I mean, you guys know that I'm a Diet Coke fiend and coffee fiend. And today I had this crazy craving for grape soda because I loved grape soda when I was a kid. I couldn't have it very often because I wasn't allowed to eat sugar. But I went over to Whole Foods today because we were picking up, wanted some really good olive oil. And I found this soda. This is not an advertisement, but if you all like any kind of grape soda, go get you an Olipop because, oh my God, this is the best grape soda I've ever had. There's only 5 grams of sugar in it. That's still a lot. Most of the soda I drink is sugar-free, but it's good for you too. It's got probiotics and botanicals and plant fiber and shit in it. It's so good. They have an orange one. They have like an orange creamsicle and like a strawberries and cream and all these amazing flavors. I'm going to try all of them because I'm obsessed now. So good. Classic grape soda, as they say in Massachusetts. Okay. Let's get through this 25-minute break and we are back. This is where I think the defense is going to rest. Try the Olipop, Amanda.
Appreciate
The
you all again
orange.
being here on time. We are ready to resume. State of Georgia versus Edrick Faust. SU 24CR0547 is state ready. State ready?
Ready, Your Honor.
Defense ready to proceed?
Yes, ma'am.
All right, ladies and gentlemen, the state has rested. Mr. Cruz?
Defense rest.
The defense rests as well. Ladies and gentlemen, that means the evidence in this case is closed. So now this is what we are going to do, and I want to tell you sort of how the process works. The evidence is closed in this case, and the next step for all of you is to hear closing arguments. There's something that has to happen before that, and it's called a charge conference. And it is a conference, it's a meeting with the court and all the attorneys about what law is to be given to the jury in its charge. That is something that, of course, has to be done outside your presence, as we have done many things outside your presence during the course of this trial, including this morning, which is why I had you come in later, because we were doing things outside your presence, and I just didn't want you sitting in the jury room for, when you could be at home or doing other things.
You're such
But
a
this
nice,
charge conference, of course, must
considerate
happen outside your
judge.
presence, and it's going to take us a while to do it. I'm going to give you a very long lunch break. I'm going to give you a lunch break until 2:30 this afternoon. And so I'm going to ask you to return back here at 2:30. I know one of the jurors has an appointment. Don't rush to come back. If you're a little bit late, it's fine. We will not start without all of you being present, so don't worry. But if you'll come back at 2:30, we're going to begin closing arguments at that time. The same instructions I have given all of you apply, right? Don't discuss the case with anyone, of course. Don't do
Man,
any
the
research
closing arguments
independently
must
or on
be
the computer.
so long.
Please don't go to any of the locations you may have heard about. Enjoy your lunch. It'll be a long one, but we'll see you back here at 2:30. Thank you very much.
Okay, so they're going to do the charge conference now. Going to lunch and then charge conference. Where's everybody?
Burden of proof upon the defendant whatsoever. I've taken this from my standard jury instructions, and I'm not sure I have that word in there, so we'll look at the pattern for burden of proof and see what it says. Certainly want to follow the pattern.
Okay. I want to skip to the jury. I want to skip to the part where she actually is instructing the jury, because I think that is probably good. Let me look at my timestamps here. Closing arguments. Well, let me go over the charge conference because I did get some notes from this. Okay. I did watch this, didn't I? Okay. Let's see. So everyone is rested. The first point on the charge conference is the burden of proof. Cruz notices a typo. She adds the exact language, quote, "There is no burden of proof upon the defendant whatsoever, and the burden never shifts to the defendant to introduce evidence or to prove his innocence," unquote. It's pretty standard. The next bullet point is reasonable doubt. Cruz requests the exact phrasing from the pattern charge, emphasizing that a reasonable doubt is a doubt of a fair-minded, impartial juror. The judge agrees to combine the paragraphs to match the pattern exactly. Impeachment is the next bullet point. Cruz requests an instruction that a witness can be impeached by disproving the facts to which the witness testified. The state objects to this, and they argue that nothing was objectively disproved, only contested. The judge grants the defense's request, which is shocking, leaving the standard impeachment language in the charge. The next bullet point is about malice murder and the justification or excuse for that. The standard charge includes caveats for, quote, without justification, without excuse, without mitigation, end quote. And the judge removes these phrases because the defense is arguing identity. Faust didn't do it, not self-defense or justification. Let's see. Motive. The defense asked to keep a sentence stating that evidence of motive can be used to determine state of mind. The judge strikes the sentence because the state did not actually present any evidence of motive. I guess I can take this off the screen for a little bit. The judge strikes the sentence because the state did not actually present any evidence of motive. That's true. I mean, that's another thing as a jury. Wouldn't you be asking, why would he do this? Nothing was stolen except for the laptop. There was no forced entry. What's the point? Why'd he do it? Ugh. All right, statute of limitations. A significant debate occurs regarding the statute of limitations for the underlying felonies, burglary, aggravated sodomy, rape, arson, etc., which is typically 4 years. The state argues that the statute was paused, because the perpetrator's identity was unknown until the CODIS DNA hit in April 2024. The judge crafts a specific instruction telling the jury they must exclude from their calculation any time period where the person committing the crime was unknown. Whatever. Let's see. Okay. Closing arguments start at 5:51. 5:45. Let's see what she has to say. Well, it's so difficult as an adult to be on time. That's it? That's it? Okay, and so I just want to make the point here that this is a 10-hour stream. We're just starting closing arguments, 5 hours and 52 minutes into the stream, which means the closing arguments are like 4 hours long. So I think what we're going to do here is, I'm assuming that the defense is going to put on a longer one. Yeah. Oh man, does Ahmad Cruz go on for 4 hours? Yep, he sure does. Yeah, they get a rebuttal recross. They get a rebuttal cross. Okay, so here's what we're gonna do. We're gonna get through Yaman Chili's closing, and then tomorrow we'll pick up with the defense's closing all the way through to the end, because there's no way I can do this for another 3 hours. I do actually have a couple more appointments today. So, okay, let's listen to the prosecution's closing arguments, and then we'll call it a day and we'll come back tomorrow. For those of you who watched the trial originally, how long did the jury deliberate? And you didn't prove it. But you didn't. And they cannot help but get digs in on Ahmad Cruz. So pathetic. Oh, shit. Oh my God, you guys. I'm so sorry.
Relates to those offenses.
I was just sitting here commenting along. I'm such an ass. Sorry.
Home and caught her as she was going through her morning routine.
Jesus. Sorry, guys.
I'm going to reposition the podium.
I wish there was a way that you could yell at me through the screen because I was just watching.
On January 19th of 2021, Tara Baker was taken out of this world. Her life extinguished by the defendant in this case, Edrick Faust. Mr. Faust entered Tara's home and caught her as she was going through her morning routine. He stabbed her, brutally bashed her head, and strangled her as he forcibly raped her, sodomized her orally, and sodomized her anally. When she was discovered by firefighters and police, her hair still smelled like shampoo. Ladies and gentlemen, you've heard the evidence in this case for 2 weeks and went through about a week of jury selection before that. And we're here at the closing argument after a family has waited 25 years for justice for their daughter. And it's time for you to write the last chapter of this story. The state in closing argument is afforded the opportunity to go both first and last in the summation. The reason for that is that we bear the burden of proof in this case. And that burden is guilt beyond a reasonable doubt. It's a burden that I accept readily. The burden never shifts. The defendant is not required to present any evidence ever. And it's a burden that I accept readily on behalf of the state of Georgia, because it is a burden that we meet by bringing you the truth, the facts, and the evidence in the case. Not conjecture, not unsupported speculation, not statements about the evidence that end up being false after you actually hear it, but the truth and the facts of this particular case. You have a 12-count indictment that you will consider. And during this initial portion of our closing argument, we are not intending to tell you the same things that we're going to tell you at the end. I respect your time. I'm going to try my best not to repeat myself. As it relates to count one is malice murder. And the law in this case will come from Judge Lott, and you should look to her jury charge in order to determine the law that applies
the
to this
defense
case.
attorney should be
But
ashamed of
Judge Lott will
himself.
instruct you that in count one, malice murder, it requires that the state
I disagree with that respectfully, Christine.
On January 19th of 2001, caused the death of Tara Baker, a human being, by strangling her with a cord and stabbing her. And in count 2 through count 5, I believe Judge Lott will instruct you that Mr. Faust is charged with felony murder as it relates to the felony offenses of burglary, aggravated sodomy, and rape. And I believe that what she will instruct you as it relates to those offenses will come in the charge, and we will discuss that. After those offenses of burglary, aggravated sodomy, 2 counts, rape, as well as possession of a knife during the commission of a felony, you will receive further instructions. And one of those instructions that Judge Lott is going to give you is about what we just discussed, the issue of reasonable doubt. And I think what the judge will instruct you in part is a reasonable doubt.
I think Ahmad Cruz put on an amazing defense and did everything he could to get everything on the record.
Based on common sense.
Yeah, this guy.
I know sometimes it can be difficult as a juror to understand how you should weigh the evidence, but I think that the end of that second sentence.
I don't know, Amanda.
I
don't know if Peter has
or
not.
Is to seek out the truth in the evidence that is presented before you. Your job is not to seek out doubt; it is to seek out truth. And the truth in this case is that Mr. Faust is guilty of each of the offenses for which he is charged in the indictment. I think it's important when we discuss malice murder to talk about what is required of the state in order to prove that. The state does not have to prove premeditation. The state does not have to prove motive. Malice aforethought in the state of Georgia does not mean premeditation. The state has to prove that Mr. Faust caused the death of another person, Ms. Baker. He did so unlawfully, meaning without any type of justification, and he did so with malice aforethought. And malice, as the term is used here, is not necessarily ill will or hatred. It is rather an unlawful intent to kill. As I said before, the state does not have to prove premeditation in order to prove murder. If a killing is done with malice, it is murder, regardless of how briefly the malicious intent existed. No specific length of time is required for malice to arise in the defendant's mind. Malice may be formed in a moment, and instantly a fatal wound may be inflicted. The malice in this case is clear. I'm not going to display in front of you now those images from both the autopsy and the crime scene that you've been subjected to. I know that they are not pleasant images to look at, but if you are looking for evidence of malice in this case, the manner in which Ms. Baker's life was taken was all the evidence of malice that's necessary to support a conviction under the laws of the state of Georgia. I think that the judge is also going to instruct you on felony murder. And although she will give you an instruction at the end, I think it's worth bringing up for you as you consider the evidence as argued to you by the attorneys in these closing arguments. And I think what the judge is going to instruct you is that for felony murder, the state must prove that the defendant caused the death of another person by committing a felony. In causation, as it relates to felony murder, I'd expect the judge will instruct you that you may find the defendant guilty of felony murder if you believe that he or she caused the death of another person by committing the felony of, and in each count, it will have the predicate felony or the underlying felony that's the basis for those felony murder counts. By committing the felony of whichever felony is a predicate, regardless of whether he intended the death to occur. There must be some causal connection between the felony and the death. Felony murder is not established simply because the death occurred at the same time as or shortly after the felony was attempted or committed. The felony must have directly caused the death or played a substantial and necessary part in causing the death, regardless of when the death ultimately occurred. And so when we're talking about burglary as a predicate act for felony murder, what we're talking about is the commission of that burglary, the entry into the home in order to commit the sexual offenses that are
how do you get into the home,
being a substantial and necessary part of causing the death. The evidence in this case establishes that. It also establishes the predicate felony of aggravated sodomy being, again, a substantial and necessary part in causing the death in this case. It also establishes the evidence in the case of the rape, and then the aggravated assault of strangulation and stabbing Ms. Baker as predicate acts of the felony murder also played a substantial step in causing her, substantial and necessary part in causing her death. So that's what felony murder means. It means committing a felony that plays a substantial and necessary part in causing the death of Ms. Baker in this case. I know that's not something that jurors typically know of necessarily as it relates to the way that the law is applied to those circumstances. So I felt like it was important to go over those things with you. The possession of a knife during commission of a felony, I think the arson in the first degree is pretty clearly self-explanatory. It's clearly from when Mr. Faust takes a blanket out of the living room, lights it on fire, and goes to start the fire in Miss Baker's bedroom. Possession of a knife during commission of a felony. Obviously, the knife used in this matter is longer than 3 inches in length. I think that's been clearly established by the evidence in the case. And then that knife was used in a felony involving another person, that being Miss Baker's murder as alleged in the indictment. So as you're listening to the evidence, those are the things that you are listening for. As it relates to the rape charge, that is carnal knowledge, meaning that Mr. Faust penetrated Miss Baker's vagina with his penis forcibly and against her will. The evidence of force and against her will is very clear from the images from the crime scene. As it relates to the offense of aggravated assault in count 5, I think that the aggravated assault being strangulation with a cord and the stabbing. As it relates to the 2 counts of aggravated sodomy, one is for the oral sodomy forcibly and against her will that was performed by Mr. Faust on Miss Baker. And then the other one is the anal sodomy forcibly and against her will performed by Mr. Faust on Miss Baker. Ladies and gentlemen, the next thing that I want to talk to you about is what is evidence and what is not evidence. Evidence is what you hear from the witness stand and the exhibits that are admitted, the videos that were played for you, and the things that will go back with you into the jury room. What I say is not evidence. Whether it was in opening statements, whether it was in questions that I asked witnesses, or anything else that I've said to you, this closing argument is not evidence. It is my argument to you about what the evidence shows. The same thing goes for the defense in this case. Nothing that Mr. Cruz says is evidence. No questions that Mr. Cruz asked are evidence. When there's a conflict between what you've heard on the witness stand and what it is that Mr. Cruz says or what I say, remember, what we say is not evidence. So when Mr. Cruz says to you that the hairs that were found in Miss Baker's hands were going to be proven to be Mr. Melton's hairs, that...
What the fuck is he doing?
Excuse me. May I see counsel to the bench, please?
Are you fucking kidding me?
Other outburst like that, those of you who have made the outburst are going to be asked to leave and you will not be able to return.
Outburst?
I don't know if everyone who made a comment heard me say this when I first got started, but this is a, well, I'll just leave it at that. If there are any other comments like that by anyone in the audience, I'm going to stop the proceedings. You will be escorted out by the deputy and you will not be able to return. And that goes for everybody that's in the audience. And I hope that I've made myself clear about that. Thank you very much. All right, your objection is?
If she doesn't hold him in contempt the way that she did Ahmad Cruz, then you're going to understand that where the bias is, because this is insane. He just tried to they're arguing. Tell us what's going on. I don't like sitting here in silence. I'm trying to watch people and read lips. I'm glad somebody in the audience.
Cruz demonstrated to you
something.
about Miss Baker fighting off her assailant while his hands were around her throat, clawing at his hands, and then reaching up and ripping his hair out. Remember what the evidence actually was. The evidence that actually came from the hair analysis told you that the hairs in Miss Baker's hands were her own hairs. Okay, so remember.
Wait, so
that
she
when
just
we're
let him
talking
keep
about what
going
the
with
attorneys
it.
say versus what the evidence is. When things have been said or claimed that were not supported by testimony from the witness stand, whatever they may be, those are not facts for you to consider because they are not facts that are established by any evidence in the case. I want you to pay close attention to Mr. Cruz as he makes his closing argument to you. And when he gets done, I'll come back to talk to you about the actual facts and evidence in
Don't
this
be a
case that prove
douchebag.
beyond a reasonable doubt that the
I
defendant,
hate this
Mr.
guy.
Edrick Lamont Faust, is guilty of each and every offense in this indictment.
Mr. Cruz, closing argument.
Wait, that was it? Oh, fuck. So he's kind of a pussy. Sorry, I probably shouldn't say that word, but he basically was like, we have the evidence, we have the proof, and he's not going to show it to you. So just when you listen to him, just realize that he's just talking out of his ass. And when he's done talking out of his ass for like 3 hours, I'm going to get up and I'm going to basically combat what he just said. So he's basically letting the defense go first, is what that just came out like, if you ask me. Yeah, apparently he gets to use his closing to bash the defense. So much for a free and fair trial, huh? I mean, I'm not a lawyer, and when I say things like that, that's coming from a place of emotion. But Ahmad Cruz was very measured in his opening, and the two things that he said, the first one was about, what was the first thing that he said that he got objected to? I think it was I know what it was. Yeah. So the first thing that Ahmad Cruz said in the opening, which we can actually watch that minute. Let me see if I can find it. It's in my notes. We'll watch the 2 moments where he is held in contempt, because I want you to compare it to what you just saw. Let's see. That's the interview with Melanie. Consent argument. These are all pre-trial. Sorry, hold on a second. Let me just look at my notes. And that's cross-examination. Okay. Day 1. Yeah, here we go. And also, the fact that the prosecutor would be totally fine speaking to the jury and talking about someone clawing at someone's hands after they've seen Chris Melton's hands. I mean, how fucking dumb do you have to be if you're trying to hide it? The Coleman-Baker Act. Sorry, I'm just trying to get to the right time code. Defense. Contempt. Okay, here we go. Where is... Sorry, I'm just like hunting around for this. I hadn't planned to do this. Otherwise, I would have already had the time code up for you guys. Sorry. Okay, let me just pull up day 1. Hold on, please. Faust opening arguments. Law and crime. Okay. Oh, Jesus. I hate that. I hate both of the prosecutors. I just think they're such punk ass little bitches. Sorry. Yeah, those hands look pretty clawed, if you ask me. Oh, so frustrating to me. Okay. Now we got time code for time code is 105 to 121. Okay. 105. All right, this is the first one.
that's the question that we're here to figure out. What happened with Ms. Baker? This is Ms. Baker shortly before she passed. This is her law school photo that she took while she was a student at the University of Georgia. And these are Chris Melton's hands after Ms. Baker's death.
They're not
So
showing
Ms.
them.
Baker
We know
was
what they look like.
killed on January 19th, 2001. These photos were taken on January 21st, 2001.
I don't know why they're not showing them.
This is Mr. Melton's left hand.
Okay, let me fast forward here.
These are Mr. Melton's right hand. During the trial, you will learn the nature of Ms. Baker's death. It was an overkill. And what we mean by that, it was terrible. That's the right use. It was terrible. It was a horrible death. Ms. Baker was not only unalive, but the person who did this to Ms. Baker, they beat her, they punched her over and over and over. And you will hear from that
It's weird to...
swollen and lacking. And then this individual, and we don't know the order, but this individual, this sick individual, then took Ms. Baker's printer cord and wrapped it around Ms. Baker's neck. And he laid on top of Ms. Baker as he pulled the opposite ends of that printer cord, strangling her. That individual, at some point, again, we don't know the order that this took place, but these are the things that took place. This individual at some point walked to Ms. Baker's kitchen, pulled out a knife out of her knife block.
This must not be the right.
And then stabbed Miss Baker in her neck. And you'll hear that Miss Baker was stabbed on the right side of her neck. This wasn't enough for this individual. This individual then went into the living room of the home, took Miss Ashley. You will hear back to
Maud likes to move around a lot.
Evidence will support that Miss Baker.
There's Chris. Why isn't this coming up? Maybe it happened right at the end here. No.
To Covington, Loganville, Gwinnett County, Georgia, every single day while Ms. Baker was attending law school.
There's a pretty big, we have to take a moment and talk about this, so we should be able to see it coming up here, but it happens twice. And you guys already know this. All right, there's the no forced entry into the house. I just want to hear what he says right before the objection. Where is it? Maybe I missed it. Thanks, D Cools. Yeah, I remember watching it too. I can't. Okay, I can't remember where it is. It wasn't that. It wasn't that. I mean, it was pretty deep into it, I feel like. All right, there's the hands. But I had the time code, and the time code that I have isn't right. But it feels like it should be because of what he was talking about. There it is right there.
One of the most important facts that you all will learn is that Ms. Baker did indeed have two.
I'm going to put this on mute and just put it at a faster speed. I mean, because I think it is really important for us to watch exactly or listen to exactly what he said for when the defense, when the prosecution said objection and what he was saying at the time. It was so measured. It was factual. And I think what it comes down to is that the argument and the judge's ruling is based solely in the 412, which is the rape shield law. So I understand the ruling, but I don't think he crossed that line. And it's me as a non-lawyer, obviously giving you my opinion, but this is crazy. Where the hell is it? Wait. No, he just likes to move around a lot. All right, let me see if I can just keep watching that. I'll put this sound on. Oh, slow down, Ahmad. Slow down.
Two other couples.
Okay.
It was him and Laura Sherling. It was Laura Sherling.
You guys keep watching that while I try to find it.
And it was also another guy and Gail couple. You, the jurors, will have to decide if Chris Melton's actions after Ms. Baker's death were consistent with someone who had suddenly lost their future wife. Next, I'd like to talk to you about law enforcement's failures. And there was a lot of failures in this case. During the trial, you will learn this case is not simply about my client, Mr. Faust. This case is not simply about Mr. Melton, nor is this case simply about Tara Baker. You will learn that this is a case of law enforcement neglect and failure. The evidence will show while this entire community was in dread and fear, law enforcement had enough evidence supporting that the person that killed Ms. Baker was right in front of them. But because of the cameras, because of the media attention, and because of the sensationalism, they have Mr. Faust sitting in that chair. The evidence will show that law enforcement knew, this is information they're aware of, law enforcement knew and ignored, as I mentioned, that all the human hair found on her body that did not belong to Ms. Baker was of Caucasian origin. You will not hear a shred of evidence that there's an African-American man's hair on Ms. African-American's hair on Ms. Baker's body. And the reason we showed you a photo of Mr. Faust with the afro is because he had a lot of hair. The evidence will show that law enforcement
Okay, I think I
conducted
might
a
have
DNA
found
test.
it.
A DNA test was done. This isn't the first DNA test. A DNA.
You guys are so patient. Thank you. I didn't expect that that closing from the prosecutors to go so quickly, honestly. But we don't have time to get into the full defense closing. Okay.
When Chris continued the interview,
It was such big news. I don't understand why I am having a hard time finding. Here we go.
told you Mr. Faust's DNA profile was not the only DNA profile present, but these are the questions you have to answer, or the state has to answer. Mr. Faust's DNA profile being present does not tell you why this crime occurred or how this crime occurred. And you have to ask for that evidence.
It actually,
It does not tell you.
D. Cools, I don't think it was the hair. There were two things. I can tell you what the two things are. I just don't remember where they come up in his closing argument. One of the things he said, he brought up the phone, the tip that was called into police that that Tara may have been at that Mexican restaurant. So he starts to posit that maybe Edrick was also in that restaurant. That's where the first objection comes from. The second objection comes from, if I remember correctly, he starts to say Tara's own boyfriend, Chris Melton, said to the police, could she have been with another man? Basically, he's like, I think he's paraphrasing. And that's the second time that they're saying it's a Rule 412 violation. And that's when he gets held in contempt. Yeah.
When the contact happened. And we don't know. It's been 24 years, 25 years. They've charged him with rape. They have to present the evidence that it was rape. The only thing that we could possibly say that you're here in the testimony in this case is that maybe when she was out at the Mexican restaurant, we don't know because they never followed up on it. They came into contact. We don't know. But that's a question the state has to answer. If you're saying it's rape,
judge isn't even paying attention.
If you're saying it's rape,
right,
prove it.
Right.
It does not tell us how the contact between Miss Baker and Mr. Faust took place.
There it is. Okay. So you just heard what he said. Compare that to what Cruz objected to, which was he was like, he's going to lie to you and say that the hair that was in her hand was Chris Melton's. He doesn't know that he's going to say that. He actually never said that in his opening. He said Caucasian hair, which he's absolutely right about because it was Tara's hair, which is Caucasian hair. And he's making the point that the only physical evidence found at the crime scene was actually zero, but inside of Tara's body, there was a speck of his DNA, which for all intents and purposes, as we understand it in 2001, was more than likely a buckle swab because they didn't test for sperm and it was excluded from being sperm in 2001. And they didn't test in 2024 to see if it was sperm. So, okay. That was the first one. The second one happens. So they argue about this for a minute. Ahmad makes some good arguments, and then he goes back to his opening, and then it's going to happen again. So I just want you guys to see what she's holding him in contempt for and what she's allowing the prosecutor to do. And to me, it's really one-sided. So that was the first one that we just watched, though. So that was the first objection. It's on the second one that she holds him in contempt. It's right here.
The sexual assault that they had in there. I may not say the sexual assault, but he knew. They told him in 2001, and that's when he came back with, I saw her 6 days
Here we go.
before she passed away. When he was meeting with Elizabeth Bigham and Jeremy Howell, they told him, hey, we found another person's DNA in her body. And Mr. Melton's response was telling. Mr. Melton himself said, sounds like she was with someone else.
He did say that.
Ladies and gentlemen, I'm going to ask you to go into the jury room for one
Just
more moment.
keep that
Please
in
don't
mind.
discuss the case.
He did say that. The third party culprit, the number one suspect for 24 years, said those words out of his mouth hole. And the fact that, well, A, I think that they're purposefully trying to interrupt this opening statement. And B, the idea that they are trying to say that this is a 412 violation and that the judge agrees with him is really ludicrous, in my opinion. Obviously, I'm not a lawyer, but so those are the two statements. And then this is her reasoning for holding him in contempt. I want you to hear what she has to say, too, because it's fucked up.
In order to get the appropriate permission from the court to introduce
It's all about appropriate permission from the court.
Evidence that another party objects to. In this particular case, it is a 412 motion. We have talked about this over and over again. What I have said over and over again is that the defense has failed to file a motion under 412. The state did. The defense has failed to file a motion, and I've said many times that if the defense files a 412,
I want us to revisit this, okay? Because here's a technicality. Here is this area where she's trying to act publicly like Ahmad Cruz has done something wrong and he doesn't know what he's doing and he is embarrassing himself, because that's what she's basically like saying to him. He filed, she is saying in open court on the record in front of national news, you did not file the proper, you didn't make the proper filing for a 412 in this case. He abso-fucking-lutely did. And he did it on January 20th of 2026. The problem is that a filing in the 412, if you want to introduce, if you want to bring in, you want to show what kind of questions you're going to be asking about a third party culprit or the police's investigation or anything that falls under the 412, which are the rape shield laws. And these are specific to Georgia. Obviously, we have rape shield laws all over the country. In order to basically complete the 412 filing that he did on the 20th of January, an in-camera meeting has to happen. And in-camera means behind closed doors with the judge to lay out what you want to ask questions about a victim's sexual history, right? So let me ask you this. This is my courtroom. Right here. This is my little pod courtroom. I am the judge. You make a filing to me asking me, hey, Mel, we think we should be able to talk to you about our favorite Olipop soda, but those rules are not permitted. So we'd like to do that. So I'm filing to put you on notice that we're going to ask for this, and this is what we'd like to do. So let me know next steps, right? Next steps are an in-camera meeting, which means you all come into my little pod and we talk about this behind closed doors, not in front of a jury. And we figure out what's appropriate to ask about a victim or about grape Olipop in front of a jury. And when we work that out, the meeting is closed and the filing is complete. Don't you think that in order for you all to come to my pod to talk about the purple or the grape soda, that you have to ask me, like I have to say, okay, well, these are the days that I'm available for you all to come into my pod. That is the part that didn't happen. She is trying to make it sound like Ahmad Cruz did something wrong here. Doesn't understand procedure, doesn't understand the rules of the court, doesn't understand how to file, doesn't know what he's doing in my courtroom. He did everything he was supposed to do. The second part of that is a scheduling conference, basically. They have to schedule a conference in camera. Who's responsible for scheduling? Like, sure, if you want to put some more blame on Cruz, then be like, well, he could have followed up. He's in the process of having to file motion after motion after motion after motion to make sure that his client is defended properly. He's having to subpoena witnesses. He's having to request discovery, which he didn't get all of. He's having to work with these jackasses over here in the DA's office. And in the meantime, the scheduling didn't happen. And so she allowed it to fall through the fucking cracks because she knew we were going to get to this place. And here we are in opening statements, holding an attorney in contempt because a meeting wasn't scheduled behind closed doors. And that is the procedure that wasn't followed through on. She says, I'm going to play this for you again. She says, proper filing. Complete the process of the proper filing. Okay? Listen to this. And this gave us a heads up as to what was going to happen for the rest of this fucking trial.
Court has stated multiple times, this is the second time today, multiple times during
Let me ask
hearings
you-
that
let me
there
ask you
is
this.
a process.
Let me ask you this one before we play this. She just made the point. The court has stated multiple times today. This is the second time today, and it's been in the middle of his opening arguments. So what is he supposed to do? He's supposed to stop his opening arguments and then go request a hearing in camera? Is that what's is that what she's expecting to happen? I mean, it's ludicrous. The words that are coming out of her mouth hole are to make him look small and weak and dumb in front of this jury, in front of the elected officials, in front of the prosecutors, and in front of a national audience. And she can go fuck off, in my opinion. Okay. Hold on.
Sexual history, being confronted with a piece of evidence and making a statement that shows consciousness.
He's still arguing his points that are in the motion he already filed. He already filed this motion on January 20th, 2026. Keep that in mind when you listen to what she has to say about it. He filed it.
As this court has stated multiple times, this is the second time today, multiple times during hearings, that there is a process that must be adhered to in order to get the appropriate permission from the court to introduce statements, evidence that another party objects to. In this particular case, it is a 412 motion. We have talked about this over and over again. What I have said over and over again is that the defense has failed to file a motion under 412. The state did.
Untrue.
The defense has failed to file a motion, and I've said many times that if the defense files a 412 motion, even though it's not timely, the court will consider it. There has been no motion filed. Mr. Cruz, you've been made aware many times.
Not in front of the jury,
you are not
no.
to bring in this kind of statement. I mean, I realize I have said several times today that opening and closing arguments of the attorneys and arguments are not evidence, and I'm going to say it again when the jury comes out. But you've been told many times that in order to, I'm talking now, Mr. Cruz, thank you.
Fuck off.
You have been told many times.
You're lying is what you're doing. You're lying.
In order to present statements like that, ask for the admissibility of evidence like that, you have to file the proper motion. And the court may consider it, even though it's not timely. As I just stated 10 minutes ago, I do find your
How are you going to say this? Choose your words fucking carefully.
To the jury to be avenues to circumvent 412.
Bullshit.
And it is not appropriate.
You're not appropriate.
I'm finding you in contempt of court. You have had the opportunity to explain yourself, and I'm finding you $1,000.
Fuck off.
And you are to present that $1,000 tomorrow morning by 9 a.m. put it into the registry of the court. And that is my sanction for continuing to not abide by this court's orders. I don't know how many times we're going to have this, but it really can't happen again. $1,000 tomorrow morning by 9 o'clock. You may bring the jury up. Thank you.
So what she just said was not for anyone else's eyes and ears except for a national audience and a local Georgia audience in Athens, because all she's trying to do is make him look like he's not a good attorney when he did what he was supposed to do, which is file the motion. And it's disgusting. It's just absolutely disgusting, especially if you compare it to what Yalamanchili just did in his closing, which we're going to watch one more time. Let me see. There it is. Okay. Listen to what he says. No, hold on. Stop sharing. I am navigating here. Okay. We got this. Okay. Oh. You're not even making a closing argument. Oh my God, why can't you guys hear it?
Is not evidence. So when Mr. Cruz says to you that the hairs that were found in Miss Baker's hands were going to be proven to be Mr.
Thanks, Keith.
Melton's hairs,
Glad you're here, buddy.
that
Okay, sorry. I need to rewind it. I was talking over him. All right, so this is what Yalamanchili said right before there was an objection. I want you to compare it to what we just watched Ahmad Cruz say in his opening where he was held in contempt. Okay.
one is for the oral sodomy, forcibly and against her will, that was performed by Mr. Faust on Miss Baker. And then the other one is the anal sodomy, forcibly and against her will, performed by Mr. Faust on Miss Baker. Ladies and gentlemen, the next thing that I want to talk to you about is what is evidence and what is not evidence. Evidence is what you hear from the witness stand and the exhibits that are emitted, the videos that were played for you, and the things that will go back with you into the jury room. What I say is not evidence, whether it was in opening statements, whether it was in questions that I asked witnesses, or anything else that I've said to you. This closing argument is not evidence. It is my argument to you about what the evidence shows. The same thing goes for the defense in this case. Nothing that Mr. Cruz says is evidence. No questions that Mr. Cruz asked are evidence. When there is a conflict between what you've heard on the witness stand and what it is that Mr. Cruz says or what I say, remember, what we say is not evidence. So when Mr. Cruz says to you that the hairs that were found in Miss Baker's hands were going to be proven to be Mr. Melton's hairs, that...
Excuse me. May I see counsel at the bench, please?
In order to commit the sexual
Listen to that
offenses
again.
that are related in the burglary being a substantial and necessary part of causing the death. The evidence in this case establishes that. It also establishes the predicate felony of aggravated sodomy being, again, a substantial and necessary part in causing the death in this case. It also establishes the evidence in the case that the rape and then the aggravated assault of strangulation and stabbing Miss Baker as predicate acts of the felony murder also played a substantial step in causing her, substantial and necessary part in causing her death. So that's what felony murder means. It means committing a felony that plays a substantial and necessary part in causing the death of Miss Baker in this case. I know that's not something that jurors typically know of necessarily as it relates to the way that the laws apply to those circumstances. So I felt like it was important to go over those things with you. The possession of a knife duration of a felony, I think the arson in first degree is pretty clearly self-explanatory. self-explanatory. It's clearly from when Mr. Faust takes the blame
He's
out of the
literally
assault
just
firearm,
going
it's
through the
self-fired, and
charges.
possession of a
So
knife during commission of
sad.
felony. Obviously, the knife used in this matter is longer than 3 inches in length. I think that's been clearly established by the evidence in the case, and then that knife was used in a felony involving another person, that being Ms. Baker's murder, as alleged in the indictment. So as you're listening to the evidence, those are the things that you are listening for. As it relates to the rape charge, that is carnal knowledge, meaning that Mr. Faust penetrated Ms. Baker's vagina with his penis forcibly and against her will. The evidence of force and against her will is very clear from the images from the crime
And the
scene.
evidence that someone
As
did
it
that is
relates
actually Chris
to,
Melton, not
the
Faust.
offense of aggravated assault.
Okay. I don't know why he spends
Is from
all
the
of his
crime
time.
scene. As it relates to the offense of aggravated assault in count 5, or evidence. When there is a conflict between what you've heard on the witness stand and what it is that Mr. Cruz says or what I say, remember, what we say is not evidence. So when Mr. Cruz says to you that the hairs that were found in Miss Baker's hands were going to be proven to be Mr. Melton's hairs, that
He doesn't say that. He's never said that. He's actually never
May I
fucking
see
said
counsel
that.
to the bench, please?
Ladies and gentlemen, you can remain.
Do you see what he
Other
just did there?
outbursts Like that, those of you who have made the outburst are going to be asked to leave in
She's more upset about the people making the outburst in the court than she is about what Yellum and Chili just tried to do. Let's watch it again.
or evidence. When there is a conflict between what you've heard on the witness stand and what it is that Mr. Cruz says or what I say, remember, what we say is not evidence. So when Mr. Cruz says to you that the hairs that were found in Miss Baker's hands were going to be proven to be Mr. Melton's hairs, that
He would never say that because he's not a fucking moron. I mean, this fucking guy. Okay, so let's see. Let's just go back to what happens right after. Oh, I think Lindsay's home. Hi, Linz.
Hi.
Let's go back to right after this conference happens, a sidebar. And then he goes back to his closing. And so you can see where he picks
Mr.
up
Cruz
again.
demonstrated to you about Miss Baker fighting off her assailant while his hands were around her throat, clawing at his hands,
So,
and then reaching up.
No, he goes right into the next part, right? About scratching the hands, which is dumb as far as I'm concerned. He goes right into that. The judge doesn't admonish anybody. The judge doesn't give an instruction to the jury. Like, remember, nothing they say in opening and closing is evidence or fact. You know what I mean? It's like, if you compare those two moments, opening and closing, and you watch the judge's reaction to them and how punitive she is, I just think it's there in those two moments, those 3 moments, I should say, where you can see the bias, you can understand the bias, and it's ugly and it's disgusting. And I'm sure I'm sure she's able to say everything that she said with a legal basis, but the idea that she is able to say in open court, you didn't go through the process of filing the 412 motion, is absolutely infactual, not factual. It's the process part of it is what she's talking about, and that there should have been a scheduled in-camera meeting, and that didn't happen. It could have happened right then and there. They've done it before, dismiss the jury, have a meeting right then and there, figure it out so everybody's on the same page and go back to it. But instead, she chooses to chastise him in front of the whole world and act like he doesn't know what he's doing and he didn't do his job. And to me, that tells me everything I need to know about this judge's bias. I don't know what the outburst was, Jeff. I would assume it might have been one of the paralegals. I could hear Cruz being like, that's not what I said. I'm not saying that. I didn't say that. I heard him say those things. So it could have been that the paralegals that were sitting at the table that she told to leave the table, which is just petty and bullshitty. It could have been one of them being like, that's not what he said, or it could have been someone from, Edrick's family who was paying attention and is like, that's not what he said. He didn't have he wasn't going to say that. He never said it. He said Caucasian hair, and he was absolutely right about that. She had Caucasian hair in her hand, and that Caucasian hair happened to be her own. That's not a lie. That's not misleading the jury. It means he's making the point that if somebody were attacking her, perhaps she would have his hair in her hand, or the hair would be on the murder weapon. Oh, wait, the hair is on the murder weapon from the person who attacked her. And that's more than likely Chris Melton. Okay, guys. I am going to take a shower. I'm going to take a breath. I might take a nap. And then I am going out with my lovely partner tonight for a group meeting of sorts to hang out, to not smoke cigarettes. And I will be back here again tomorrow to finish up. We'll go through Ahmad Cruz's closing tomorrow, and we'll listen to the rebuttal. And that will be that until the jury comes back with a guilty verdict, which we already know is going to happen, sadly. And I really want to think about next steps tomorrow. So if you all have any ideas, if you want to email them to me or you want to post them on the YouTube in the post section or the community section, or like I said, post them on the Facebook. The private group is Something's Off with Mel Barrett and Rebecca Lavoie. Please go become a member over there because we have great discussions, but post your thoughts, post your ideas about how you want to get involved, and we'll start working on that as a group. Oh my God, I love Costco dates. We had a Whole Foods date this afternoon. That was what we did for lunch. That made me very happy. Somebody said something. Oh, hey, Sarah, thanks for becoming a new member. That's amazing. We love you. I wish I knew what that outburst was now. Okay. I will be back tomorrow. Oh, also, a lot of you have been asking about Newslight, and basically I think what I'm going to be doing with Newslight is once a month because I do not have the time or the capacity, even though I love that show and I love talking about politics. I don't have anybody that can book me guests, which proves to be like the hardest part of that show, not the research or the talking points or anything like that. But I am going to do a special Newslight. It might happen tomorrow night. I'm waiting to hear back about Ellen's schedule, but I will be having my friend Ellen Marie Marsh from I Think Not and Shut the Fuck Up Nick Lachey back on the show. And we were going to be talking about some happy news, the Rape Academy. It's not happy at all. It's probably going to make you crazy. It's enraging. But the Atlantic just did this huge story. It was either the Atlantic or the New Yorker, and I can't remember which one it was. I'll look it up. Well, we're going to be talking about this online place where men go to figure out how to best sexually assault or grape the women in their lives, or stranger women. And it's just being uncovered now, and it's disgusting, but we're both fired up about it. And on our regular show, so my Something's Off with Rebecca, and she does I Think Not with Joey, the rundown. Neither one of our partners want to talk about that on our shows. So we're going to talk about it on Newslight because we both feel like we need to talk about it. So I will let you know when that's coming up. And of course, I'll put out, a live notify me. And I will see you back here tomorrow for Ahmad Cruz's closing arguments. I appreciate you all so much. Please don't forget to like the video, subscribe, share, comment, leave a tip if you can, grab something on the wish list if you can, become a member if you can. Okay, that's all I'm doing for grifting today. Love you all. Thank you for being here. Thanks for the support. And I will see you